Okay, thank you everyone for joining us for this employment law update, the first one that we are running as a firm, looking ahead at the year to come, 2023, what we can expect in employment law, and a bit of crystal ball gazing to see if there is anything else that we can speculate about and see how the land lies. For those who don't know me, my name's Antonio Fletcher. I am head of the employment team here at Whitehead Monkton, and that's really all I need to say in terms of introduction. And here on this slide that hopefully you will be able to see, you can see an outline of what we'll be covering off today. So first of all, just setting the scene, having a look back slightly over the last year or so to understand where we are, thinking about potential changes ahead, changes to the economic circumstances and how they might impact on the employment environment. Thirdly, one of the things I think may become increasingly a key point over the course of the year is redundancies. So it's just a quick refresher there in terms of things to look out for and avoid, and hopefully sort of refresh everyone's knowledge of redundancies and redundancy processes. Fourthly, I'm going to talk about the Employment Tribunal, the current situation with the tribunals, and what we can perhaps expect there in the future. And then finally, it's the changes to the law that are coming up in the year ahead. Some of them, actually most of them, are not certain, but are things that we can sort of see at least an outline of at this moment in time. So if we do a bit of the scene setting of where we are at the moment, we've had a pretty unique set of circumstances, it's fair to say, over the last couple of years. So global pandemic starts us off, and all that has brought. We've had Brexit. And again, the many and varied impacts of that on day-to-day life. But from an employment perspective, we had unemployment rates at the lowest level for nearly 50 years, and they're sort of actually maintaining that level fairly steadily even now. In early 2022, so looking back a year ago, there were more job vacancies than unemployed. And an interesting PwC survey from March last year concluded that 18% of people were very or extremely likely to change jobs within the next year. It'd be interesting to see actually how many of those 18% have done so. And the number of people changing jobs hit record highs. So obviously in the past we've had circumstances where people have left employment, perhaps not voluntarily, in times of economic crisis, etc. But this is people willingly leaving work and looking for new jobs at a time where I think it's fair to say that it was very much an employee's market on the job front. What we've also had as a consequence of the pandemic, possibly as a consequence of Brexit as well, is many experienced and skilled workers leaving the workplace. Now, whether that's been people who perhaps would have retired during that time period anyway, people who have chosen to step away from work as a consequence of pandemic-related issues, particularly with an eye on their own health, people who have family overseas and that may have found the pandemic a particularly trying time for them, and have decided perhaps to relocate back closer to family and roots and things like that. So we have had a real deficit across a range of sectors of experienced and skilled workers. The recruitment from overseas has obviously become more challenging for similar reasons, Brexit being a key one. Secondary factor it can be traced back to the pandemic, people making life decisions about where they want to live and work. So retention and recruitment have become priority issues with employers, and they've obviously adapted working practices partially down to the pandemic, but also partially in a bid to retain and recruit staff. I think it's fair to say that in respect of most job interviews at the moment, from a candidate's perspective, the key question was always, well, how much am I going to earn in this job? But that's now very closely followed by how many days can I work from home, or what are the working arrangements like? So the fact that we really do even now still have a strong market for employees means that employers have had to adapt to that, and perhaps some employers who may not have been particularly comfortable with things like home working are now having to very much change their views and adapt accordingly. Now, in that backdrop, as then we progressed on in 2022, we then had a further set of sort of unscheduled and perhaps unexpected set of circumstances. A lot's been talked about, how the war in the Ukraine has impacted certain issues, and that has undoubtedly added to the uncertainty. Certainly let's call it the last government, so the Liz Truss government, their interlude in charge of the country certainly shook things up somewhat. And this has resulted in, towards the end of last year, the Bank of England announcing a 2-year recession. Sort of with the fact that we were at the beginning of that, or just about to go into it. There was talk about an expected rise in unemployment rates. Some scary talk of unemployment rates doubling and things like that. Well, to be honest, even if they did double, we would probably be at around what we would consider to be a fairly normal level of unemployment. So there's clearly an element of scaremongering in terms of some of the headlines around this, but the cost of living crisis is certainly undeniable. The added expense and pressures on households, and all this has contributed, let's say, to life becoming less and less affordable to most people, and that has then triggered the mass industrial action that we have had across multiple key public sector services in particular. But undeniably, those public sector actions have and will have impacts on the wider economy as well. If we think of simple, sort of the most simple example being rail strikes and other travel related strikes that will impact commuting, that will impact the ability of people to meet and do business, albeit we do have much better remote systems in place now than we would have done a couple of years ago. Things like just simply being able to hop on a train for a business meeting will undeniably have an impact. And if you then trace that on to things like education, teaching strikes, schools being shut. I think today is the first day of teachers striking in Scotland. I think that the mention on the radio, 300,000 children at home today that would normally be at school. Well, that's going to impact on parents and arrangements that they will have. So again, lots of uncertainty and lots of things that are chipping away and bubbling away that could impact the employment market and the employment situation. Going forward, and even now, we're starting to see this increasing pressure on employers to balance the books, to deal with these additional costs that they're facing. Again, compared to what was initially announced in terms of support that might be there for sort of the gas and electricity bills, it seems like the government now is much less committed to dealing with these, certainly in the long term. And there is a need for many employers to try and find that money within their budgets to just cover the extra costs that they're facing. And coupled with that, the pressure is undeniably on employers to keep wages high, because there are clearly still gaps within the workforce, and B, because individuals are demanding that. So that's all adding to the burden that employers face. And there may be a time now where employers start to shift in their mindset of actually thinking, well, do I want to retain this person? Because I'm going to have difficulty filling their role if they go, or am I going to have to take some braver decisions, put more of an impetus on people within my team to cover all the duties and make some difficult decisions? Because cost saving is undoubtedly going to be near the top of most people's agenda. Added to this, the fact that we've had such a mass change of or shift around the workforce will mean that many individuals who have recently changed job actually have short service and very limited employment rights. They won't have protection from unfair dismissal, for example, if they change jobs within the last 2 years. And then you have the continued increase of use in things like AI and automation that will become increasingly attractive to employers who are looking for cost savings. So it does beg the question whether actually it's still an employee's job market now. I think you'd probably say, well, yes, at the moment it is, because there are that many vacancies still around. But actually looking ahead in the next few months, that question has certainly more doubt around it. And as I mentioned, some employers beginning to take steps towards shaping their working practices for the longer term. So up until now, I think it's fair to say that most, or certainly a lot of employers, are still using practices that they had to implement very quickly during the pandemic to ensure that home working, remote working was possible and practical. But actually, there's only been a few tweaks, let's say, to that over the last year or two by suggesting people come in maybe 2-3 days a week more regularly and things like that. Well, actually now you're starting to see employers shaping the practices much more to their needs. So obviously there's been talk in the media of certain law firms, for example, saying that's fine, you can continue to work in a hybrid fashion, or you can continue to work from home, but actually there's a salary reduction that then needs to happen if you're no longer based in the London office and you don't come into the office every day, or much more of a demand to say you need to be in the office X number of days a week, or simply carrying on, but chiseling aspects of home and hybrid working to better suit the needs of the employer. And that's indicating perhaps that there is becoming a bit more of a shift in power from the employees to the employers in terms of the market generally. Recruitment and retention are certainly still likely to be a concern, particularly for many sectors. Inevitably, a lot of the talk in the last few days around the strikes of nurses, for example, is that people can earn more money working, for example, for Sainsbury's than they can as a nurse. Well, the reason for that is clearly because Sainsbury's have recognised, or press have recognised, that it's important to keep their salary levels at a good level to keep um, to keep workers within their industry, because otherwise they are going to face the same recruitment issue that they faced up until now. That again continues to have this knock-on effect in terms of salaries going up, costs going up, etc., etc. And this continued uncertainty is likely to carry on for many months ahead. It may go one way, it may go another. If the labour market gap continues to be the main priority and the main concern for employers, then you probably are still going to see things stay largely as they have for the last year or two. If, on the other hand, the need to cut costs and reshape becomes much more pressing, then things are likely to change and may change fairly dramatically. And that brings me on to the next section that I wanted just to talk through. This is not in any way intended to be a full guide on redundancies, but it's a number of key points I think that it's always worth bearing in mind, and I'm conscious that we've got some very senior HR people here on this call that will have gone through redundancy processes many times. So I don't want to teach anyone to suck eggs, but these are, I think, useful reminders to have at the forefront of our mind in the next couple of months, because this may be an area that actually we've not, as professionals, had to do a great deal of work on over the last couple of years or so, but may well become a key factor in the months and perhaps the years ahead. So thinking about what triggers an employer to think about making redundancies, well, there may be the core, if you like, the core reason for making redundancies, a reduction in work levels. That may lead to a need for less employees carrying out particular functions, less employees generally, or outlets and particular venues, for example, being closed. Others may simply face pressures to cut costs and therefore think about restructuring the workforce generally as a means of reducing that expenditure. So spreading the work out differently to what they do now to create an ability to make cuts in the workforce. And employers need to be mindful of the test of what actually amounts to a redundancy situation in law, because the simple need to cut costs in itself would not necessarily trigger that redundancy process, the redundancy from a legal definition. So the definition of redundancy, there's three situations. Either you've got a business closure, the employer ceases to do business altogether, the employees are consequently redundant because the business is no longer operating. Secondly, a workplace closure. So the site where the employee works is closed. Plenty of examples of this. Very recently, I think yesterday in the news, there's talk of Amazon closing. I think a couple of warehouses, and the consequential hits could be about 1,200 jobs in those areas. So that's not as Amazon stopping doing business, it's just simply changing the way it's doing it and closing a couple of its sites. Thirdly, diminished requirements for employees to do work of a particular kind. Well, that's your more traditional situation where there's not the level of work needed to warrant employing particular numbers doing certain things, or that could be the restructure scenario that you've looked at the organisation of the business, you've taken certain key duties out of particular roles, reallocated them, redistributed them elsewhere, and that has given rise to the potential no longer having a need for particular roles. So just going back on that slide, actually, it's important to make sure that when you're talking about a redundancy situation and you're thinking about going down a redundancy consultation route, that you're mindful that for it to be a redundancy, you've got to have one of those sort of three scenarios there. Moving on to collective redundancy, always the key figure is 20 employees. If any proposal where 20 or more redundancies will take place within a 90-day period at one establishment will trigger collective consultation requirements. It's really important to be mindful of the wider definition of redundancy for these purposes. We're not just talking about the redundancy we mentioned a moment ago, where, for example, individuals' terms are varied and you're looking at a dismissal and re-engagement process, for example, those individuals that are affected by that situation would need to be included within the numbers for collective consultation, and it's important to be mindful of the 90-day period as well, and the fact that we're talking about proposals for redundancy within that period, not necessarily the materialisation of them. And lots of case law around what's the meaning of establishment. I'm not going to go into all that now, but it's worth bearing in mind the establishment looks at both the geography, is it a standalone site, for example, but also the organisational structure that's behind it as well. Collective consultation is so important because there are very high risks in getting it wrong. Being mindful of those 20 individuals, keeping track if you are making redundancies over a period of time, it becomes very important because getting it wrong really does have serious consequences. They include criminal sanctions if the Secretary of State is not notified as part of that collective process. There is a need to notify the Secretary of State where more than 20 redundancies are proposed, and if that is not done, that does potentially carry criminal sanctions. Protective award as well of up to 90 days pay per employee if the collective consultation requirements are not met. That's not a compensatory award, that is a punitive award, if you like. It's not there to compensate employees for loss. It is there primarily to make sure that people do what they should do, because the costs of sort of, let's say, 20 or 30 people even, 90 days pay for each of them for getting it wrong, starts to, particularly if it's a cost saving necessity, starts to certainly erode any benefit from cutting corners. The minimum consultation period increases as well if more than 100 employees are at risk, so from 30 to 45 days. So again, really important, particularly if we're getting into those high numbers, to keep track of how many people are involved, and that collective consultation process needs to be longer to avoid those risks. Collective consultation needs to be with representatives, so there is a need to elect employee representatives before going down that consultation process, particularly where there's no recognised body that deals with collective consultation on redundancies within an organisation, which would be most organisations, unless they are unionised and elements of or all of the workforce are within a recognised union for those purposes. It's important to allow time for that election to take place. generally speaking, you at least need to think about a week of to dedicate to that before the consultation can start. Everyone needs to have the opportunity to vote, and everyone needs to have the opportunity to do so in a secretive way, and to go through all those requirements. And key amongst those is making sure that there is adequate representation for everyone. So whether you split employees by location, or you divide them by job role, or other similarities they have, you just, where you identify the groupings that will have a particular representative, it's really important to make sure that everyone has a representative that is in a similar position to them, that will be raising the issues that they would expect to be raised in the collective consultation, and also that they have access to the representative. It's tempting to sometimes keep the numbers of representatives low to have a manageable process, if you like, and make it easier to have those discussions with people, but in ensuring that people, the rep doesn't cover too many people, if you like, and has the ability to feed back to them and look after all of their interests, is important too. And the consultation process commences with the provision of the statutory information to the representatives once they're elected. So it's really important to keep track of when that takes place, because that will be the kick-off of the 30 days, or the 45 if a longer process is needed. It's very important not to sort of miscalculate or be tempted to for example, count the election process as part of that process, because it's simply not going to cut it. Where I think any redundancy process is concerned, but particularly collective consultation, preparation is the key. Needing to be very clear on what the proposals are, setting them out clearly, having a plan, and as to how that consultation would go, and how the messaging is conveyed, and the points for discussion, maybe even trying to anticipate what likely questions people will have, as much as you possibly can, is really important as well, because that makes the consultation process more meaningful. B, generally means it runs much more smoothly, because the right questions are being asked and the right questions are being answered promptly. It helps to engender that goodwill in what is generally a difficult situation. So it's again important to try and prepare as much as possible. Think about the pooling, think about the reps, think about all aspects of it as much as you can. It's also important to recognise that consultation is with a view to reaching agreement with appropriate representatives. It's not going to be possible to do so on every occasion. That would be too high a threshold, too high a level of expectation to place on any consultation process. You've got to try and reach an agreement as much as you can. And make sure the consultation process is meaningful. Those are the key points. Also, really important to be mindful of the fact that the collective redundancy consultation process does not replace the need for individual consultation, which also would need to take place as well. Pooling, whether it's part of a collective consultation process or not, is really a really important part of any redundancy consultation. It needs to be considered carefully, but it's also important to note that there's generally no right and wrong way of selecting a pool. There is a relatively wide scope in compiling the pool, and an employer making decisions as to how individuals should be pooled. clearly, any decisions that seem completely perverse or designed to reach a particular outcome would not be looked at favourably by a tribunal, and pools of one are particularly likely to receive a bit more scrutiny from a tribunal if a tribunal were to ever look at these. But that doesn't mean that pools of one are not possible. You know, where you generally have standalone roles, generally unique duties, or location of work, for example, it may well be appropriate to look at a pool of one. But you just need to be prepared to be able to justify that perhaps a bit more robustly than where a number of individuals are being considered in a wider selection pool. Also, really important where you're looking at pooling, to consider the criteria for selection very, very carefully. I always think objective rather than subjective is key. Anything that is measurable and factual rather than opinion based stands up to scrutiny so much better. And you also need to be very careful that the criteria you use is not discriminatory. So thinking about, for example, individuals who may have absences relating to disabilities, who may have had to take appointments or have additional flexibility for, let's say, maternity-related issues, things like that. So definitely consider the criteria very carefully, and also think about potentially actually the wider scope of what you're saying. Indirect discrimination can trip you up as well. So sort of things like flexibility sometimes are tempting to use, but be careful about what that actually means in practice, and also be careful of how you measure that, and try and think of it again more objectively than subjectively. Where you have a redundancy consultation, you need to make sure the proposal is set out very clearly. That goes back to the points I made a few moments ago about planning, whether it's a collective or individual consultation. Make sure that time is spent setting out the proposal clearly so that everyone knows what is being proposed and why. And the first individual consultation meeting that you would have with someone is a great opportunity to go through those proposals in detail, and explain the rationale, and obviously invite comments as well, and feedback from the individual as part of the consultation process. Obviously, they need to be able to put forward their suggestions and put forward considered replies as well. That's why I would generally advocate in a redundancy consultation process to have 3 meetings with an individual. The first one is a lot about conveying information to them and maybe clarifying information that they may have got in an initial communication. So to expect too much from the individual then it can be a bit unrealistic. So having that second meeting for them to really put into detail any considerations that they want to put forward before communicating a final decision at the third meeting, I think it can be very important, and obviously allow the scoring and pooling to be challenged and provide the lowest safe score to individuals as well. Touched on that in terms of having at least 2 further consultation meetings with them after the initial announcement communication of information. As I say, I would say 3 consultation meetings ideally. Meetings spread over the course of at least 8 to 10 working days, and appropriate notice being given, as well as the right to be accompanied as good practice. Consultation should focus on the proposals. That's why being clear on the proposals is so important. Any alternatives and other points of challenge that the employee may have, but also giving information about what the redundancy terms would be. Decision should be given at the final meeting and then obviously followed up in writing with a right of appeal and arrangements being put in place for the appeal to be dealt with promptly. Moving on now to employment tribunals. Current position, well, if we look back further in time, what were employment tribunals introduced to do and to be? Well, they were originally intended to be less formal processes and venues than courts were. There was an intention that this would lead to cases going through the system very quickly within a number of months, 5, 6, 7 months at most. However, cases have become increasingly complex. I think it's fair to say that the reason there are employment lawyers in this world is because employment law is not a simple thing. It's not something that's necessarily accessible to people who don't spend their time working in this area. And the complex situation we have in tribunals at the moment is we've got tricky laws, tricky legal principles, often as complex or more complex than many court cases, but you've then got high levels of self-representation because no win, no fee kind of representation isn't particularly viable, because individuals who find themselves in employment tribunals are often doing so because they don't have a means of earning money or have lost money, so they can't pay for the legal representation, and the cost regime within the tribunal means that you're very unlikely to recover costs whether you successfully bring a claim or defend a claim. So this often means that you've got fairly high levels of self-representation, which goes back to actually what the tribunals were intended to be, but a much more complex process and much more complex legal proceedings that result in the process itself often taking a lot of time to get through. Looking at current tribunal statistics, so between July and September 2022, there was a 6% year-on-year increase in cases. So compared to July-September 2021, there's 6% more claims going in this year than were last. During that same period, there were 18,000 new claims received. The tribunal system was only able to dispose of 13,000. So that means that between July and September, the number of cases that were added to the stockpile of tribunal claims, if you like, was 5,000 more. So this is a continuing trend of more claims being added to the system than it can actually work through. It can take several months at this moment in time to simply list a preliminary hearing on case management. Several months, actually, in some cases, actually quite generous. I know of cases where it has taken a year just to get a half-day preliminary hearing, and that's definitely not going to help anyone. Currently, we've had information from the user group of our local tribunal, which is London South. The cases that require hearings lasting multiple days at the moment are being listed in late 2024. So this is realistically from when someone has issued the claim, the tribunals received the claim, it's going to be at least 2 years before someone manages to get their case into the tribunal, and that is unworkable really for most people. Now add to that they may get that listing for late 2024, but realistically that listing is not going to be an exclusive guaranteed you will definitely be heard on that day listing. It's going to be probably with a number of other cases alongside it. So it's not unusual at all, unfortunately, at the moment, for cases to be postponed on little or no notice due to lack of available judges, because of the tribunal's time is so precious at the moment that the idea of having a day or a week, heaven forbid, with no hearing in place because it's settled at the last minute is just not an option. So you then have this situation where you've got 2 or 3 cases listed at the same time, and when they don't settle, there's no judge available to hear them all. I had a situation earlier this year, unfortunately, where the case was due to start on a Monday. It was all going ahead. Monday morning comes, and it's only Monday morning the first we hear that there are murmurings that it's not going to start at 10 a.m. as scheduled. There'll be an update at lunchtime. Lunchtime comes, and we're told, unfortunately, the case that they were hoping would settle isn't going to. So our 5-day hearing just does not go ahead at that point in time. And the first we hear about it was on the day, and actually it's sort of midway through the day that a decision is made that this hearing is not going to go ahead. And that covers a lot of frustration on the parts of clients, a lot of cost on the part of clients. Barristers' fees will have been incurred to a certain extent, and it's a very difficult, unworkable situation at the moment. Now, going back to what we were talking about, the current employment market going forward, well, actually, if anything, we face an increase in tribunal claims. If unemployment rates were to go up, if it became more difficult for people to find new jobs after they leave their current job, if redundancies were to increase, then a system that is already clogged by what is, generally speaking, a fairly low level of claims over the last few years, by a spike like even that's half of what we had over the last recession, for example, the system's just not going to cope at all. It's going to become, frankly, unworkable, I would say. The other impact of people taking more time to find work if they were to become unemployed is that the value of their claims would increase, because if you think of even a simple unfair dismissal claim, the majority of losses someone can claim for is simply their loss of earnings. If the amount of time they spend out of employment increases, so does the value of the claim. That entices people to bring a claim much more than a lower value claim potentially would. And it also often means that the claims become more complex as well, need more tribunal time, may need an extra preliminary hearing, all these sorts of things that will just mean that the process becomes even slower. I think it's beyond the simple fact of being taken as tribunal and the losses that an employer can incur if it's unsuccessful in defending a claim against it. It's very important to be aware of the hidden costs, if you like, of tribunals. I mentioned postponed hearings. They are very much a reality of tribunal litigation at the moment, and that does make the process more expensive. You prepare for a case, your legal advisors spend time preparing for a case, you incur a brief fee for a barrister to prepare the case, to go to hearing, you sometimes show up at the hearing itself. And those are costs that are incurred and maybe fruitlessly incurred if you get a very late postponement. as I mentioned, the chances of recovering your costs at tribunal are slim. There are things that can be done to help the chances of recovering costs, but even then, the chances are generally very limited. The management time that is involved is always something that that shouldn't be disregarded. Whether that's talking about settlement options, talking about strategy, spending time worrying about a particular case, all takes up time and resources away from employers. Witnesses, obviously, you think about their time involved in preparing their evidence, in giving their evidence, in again, potentially sleepless nights worrying about what going to a tribunal means for them, but also the fact that witnesses, when you're talking about hearings may be taking place 2 or more years after the claim was issued, or the claim itself may be referring to issues that happened a year or maybe even 2 years before the claim itself was issued, at least in part. So witnesses move on. We've talked about the way the job market is. Lots of people have changed roles in the last few years. That may continue. So witnesses you need to properly defend your case may no longer be your employees. Even if they are, their recollections may not be what they were. So in a way, it's important to try and do things like prepare witness statements as early as possible, so that recollections are at least fresh at the time that the witness statement was prepared. Also, really worth thinking about things like the fact that a tribunal hearing is still, be it less formal, it's still a public hearing. Members of the public can attend, journalists can attend. The decisions are now posted online and are fully searchable. I know of clients who have suddenly seen summaries of their cases published by other lawyers commenting on them, because people do look up certain names of companies or certain types of institutions to comment on topical case law for their own clients. So all this carries greater reputational risks, especially when you think of certain types of claim where discrimination is involved, for example. It's undeniable, I think, that there is a greater reputational risk now in being taken to tribunal. Lots of tender opportunities do ask about discrimination claims, for example. And also thinking about the effect on wider staff morale if issues become prolonged. I've been involved in a number of cases over the years where, for example, individuals have been named respondents, and as much as you try and give them comfort that the claim has good chances of success, that the defence has good chances of success, and the risk to them should be relatively low. At the end of the day, they are still effectively being sued as individuals, and it's not a nice place to be, particularly if you're thinking that the claimant may be cross-examining you in person. All these kinds of issues that may impact on people and on morale at a time where retaining your key staff and your important staff is really fundamental. Moving on from tribunals, I'm conscious of time, and I do want to talk about a few of the legal updates that are on the horizon. First of all, the retained EU law revocation and reform bill. Now, that received a fair amount of attention a few months ago, in that it was the proposed legislation that will, in essence, remove EU law from our statute book, save to the extent that it has actually been positively brought back in to in some other guise into our law. Now, lots of opinions on what that means in practice. I've heard it described as, in essence, from anything to an affront to civil liberties and the way that we live and conduct ourselves at the moment, to actually quite, certainly in the sphere of employment law, maybe not that major. I think the truth lies somewhere in between. I've written an article which is sort of on our website, sort of setting out my views on this back when this was first announced. I do think there is going to be change in employment law. What exactly this bill will mean in terms of employment law, it's too early to say. The earliest this will all come to pass will be at the end of this year. More realistically, it's going to be prolonged for a couple of years at least, until this is all ironed out. But there will be change in the horizon. What exactly that will mean, I think it is speculation at this time. But where you think about things like working time regulations, the agency worker regulations, less popular and more admin heavy, let's say, regulation are going to be the areas that are likely to be targeted by things like this. And there is always this stated need to remove red tape. That seems to be one of the clear messages that was put out at the time of Brexit, and that will be seen to be one of the successes, let's say, in removing red tape as much as possible. I don't think it's going to lead to a complete overhaul of our regulation. A lot of rules are popular, are necessary. And I think of things like TUPE when I say that, have been popular with employers. Yes, they are complex bits of law, but they provide a framework that most people are comfortable with now and can readily get advice on. So I don't see that areas like that will change. I don't see that there'll be a significant change in areas around discrimination or things like that. But as I say, we probably will see changes to some of those less popular pieces of legislation and that are viewed as cumbersome. There's the increase in national living wage. Obviously, there's an annual increase in the living wage and minimum wage every year, but quite significant this year. This obviously then carries with it a knock-on effect on the cost of things like pension contributions and taxation. And in this chart here, we are seeing significant rises. So the current rate of the living wage, £9.50. That's nearly £1 increase to £10.42. 21 to 22-year-olds, that is £1 increase. And similarly, for younger workers, etc., we're seeing an increase there. Now, clearly, where employers have numerous members of staff on lower wages or who are paid the living wage, that will have a massive knock-on effect on costs, where we're talking, sort of 10% plus increases in pay. Flexible working. So there's a stated desire to increase flexible working rights. So the outcomes on the consultation on flexible working were published towards the end of last year. This includes notably a day one right to request flexible working. So on the first day of employment, no need to wait. People can make a flexible working request. whether that's in relation to locations, hours, etc., etc. Up to 2 requests can be made in any 12-month period, so that's up from only 1 request a year. And there is going to be a positive duty on employers to discuss alternatives where the where the request is put forward. You can't simply say no. You need to try and find workable alternatives, and a more simplified procedure in terms of how the individual would be able to make that request. Now, at this stage, this is, as I say, it's an outcome on the flexible working. It's likely to be adopted. Time frame in which it would be adopted is yet unclear. The government was certainly accused of dragging their heels on publishing this consultation, so it's perhaps not too high on their list of priorities to implement, but it's certainly something you can see, sort of being implemented within the next year to 2 years. The fire and rehire code. Now, this seems to be a very unpopular practice within the current government. The dismissal and re-engagement, as we would call it generally in the legal sphere, the sort of offer of the method used for changing terms of employment where agreement generally can't be reached, of serving notice and immediately offering re-employment on the new terms, is viewed as a very unpopular practice, and I think if the government's view sort of questionable, question the morality around it as well, which to an extent is understandable, but certainly takes away a lot of flexibility from employers in terms of looking to put forward change that sometimes are very necessary for the survival of businesses or the economics around employment. So there we're likely to see some kind of code being published as to how those sorts of processes should be dealt with in future, if at all. We have a data protection and digital information bill on the horizon, which is designed to simplify data protection matters. That will no doubt impact on a number of areas of employment, the employment relationship. Again, no sort of fixed rules around that. Lots of recent talk around the employment allocation of tips bill. Again, that is primarily designed to benefit the employee in the hospitality sector in particular, to ensure that employees get to keep the full tips that are left by customers, and that employers don't encroach on that. That seems to be, perhaps a slightly populist bit of legislation, but also I think arguably one that many people would view as fair. Additional family-friendly rights, so extending the redundancy protection during pregnancy and maternity compared to what it is now. Additional leave being granted where a child is in neonatal care, carer leave, and also much more in terms of rights around fertility treatment and appointments around those. All those very much on the horizon. Not sure again when exactly those will be implemented, but these are all things that we can expect to see and have much more clarity on within the year ahead. And then finally, this is a slide I've added in this morning following announcements yesterday. So the minimum service level strikes bill allows minimum service levels in a number of sectors. So if strikes are called, key generally public sectors, will be required to have minimum staffing levels to allow the sectors to operate. These include health, transport and education. The government has said that they are hoping to deal with this primarily only with fire, ambulance and rail, and not have to go down the route with other sectors, including education. But all that remains to be seen. Certainly the bill would allow scope for minimum service levels in education. Employers would have the ability to identify the employees that are required to be at work in order for those minimum service levels to be maintained, and they would be prevented from joining strike action. And from the trade union's perspective, the stick there is that if they don't take steps to ensure that compliance takes place and those individuals are available to provide those minimum service levels, the union would lose its liability in tort. It's protection from liability in tort, I should say, for inducing breaches. So currently, strike action is inevitably a breach of contract, and trade unions are protected in tort from inducing a breach of contract, but that protection would go away if they don't take steps to ensure that those minimum service levels are maintained. Now, clearly, that has a direct impact on employers within those key sectors, in giving them hopefully more flexibility. I think in terms of maintaining a service level during times of strike, but it also, I think, from an employer's perspective, is likely to be viewed positively, because when you think about the impact that strikes in transport and education, which we talked about before, do have on the wider economy, then hopefully that would be reduced from an employer's perspective, because people will still be able to travel. They'll still hopefully have the ability to send their children to school, etc. Excuse me. I won't take any questions now because I'm very conscious of time, but please do stay a moment if you can, because we will launch a poll in a moment just to get feedback on this webinar. I would be very interested to know about any topics that you'd like me to cover, or you'd like us as a team to cover, because I think the rest of the team are keen to get involved in future webinars as well. And we will very much try to adapt future webinars to what you would like to hear about. From my perspective, I would like to thank you very much for attending. It's been very positive from our part to get a lot of interest in this webinar, and lots of you being able to join us. So thank you very much for that, and I do hope to see you all soon, speak to you all soon, and if not, that you'll join us at our next webinar, which we will hopefully run shortly. Thank you very much for your time, and hope you have a good rest of the day.